start now?
Yeah, but I can't guarantee I'm going to be this close to the mic the whole time.
This has been a journey. This has been a 10-minute journey to just start recording for the third time.
Do you know what episode it is? I think it's
23.
Is that right?
23.
Wow.
We're climbing.
Okay.
Welcome back to Subject to Cross, listeners. I'm Caroline Donato, one of your hosts.
And I am Pete Kratza, one of your other hosts.
Quick housekeeping. We've had a few nice emails about suggestions about what to do.
When you say we, I never see these emails. Do they only come to you?
I forward them to you. A lot of them do come to me.
Really?
Yeah.
How do we get them?
You know, I'm going to put this mic literally right in front of my mouth. I think you should do the same.
Don't tell me what to do.
I suggest you do the same.
That's as close as this thing's getting to my face.
No, I'm just saying, like, you had it on a diagonal.
Yeah.
We'll just put
it's still on a diagonal.
Okay.
Yeah.
All right. So one of
Where do those emails come from? Where do they go?
Some come from other lawyers.
But, like, is there an email address?
Well, there's Subject to Cross. Oh, you led me there. That was nice. Subject to Cross at McElree.com. McElree is spelled MACELREE.com. Subject to Cross. If I need to spell that for you, don't email me.
But it's all, like, written out, subject to cross.
There's no spaces. There's no underscores.
Okay.
Subject to Cross at McElree.com. Or they email me directly.
So when they send emails to subject to cross at McElree.com, are you the only one that gets them initially?
You get them too, but you don't pay attention.
Are you sure?
Yes, and then I re-forward them to you.
And
then you ask me
attention.
questions.
Yeah.
And I say, yes, we can do this.
Okay.
But some of the suggestions so far require quite a bit of prep.
Which I do, and you do not.
I prepped this one.
How many articles did you read?
1, 2, 3, 4, 5.
I think you just made that up.
Look,
1,
I can count.
2, 3, 4, 5, 6.
Why do you have 6? Because Donna literally
I
made
always
you...
go the extra mile, Caroline.
Did you get an extra
to
one?
this podcast.
Did you get an extra one
I
by
may
yourself?
have. Yeah.
You used the internet?
Remember when we did the dog thing and I had like a law review article?
Oh, blew my mind.
Yeah, I know.
Okay, well, back to the housekeeping. We will follow up with your suggestions. We appreciate them. Please keep them coming. We will have a guest. We have a guest in mind. I'm not going to say exactly who the first one is because I don't want to commit, but we'll have guests.
So that was one of the emails.
That was more than one, yes.
Oh, okay. What were the other ones?
Suggestions. But
like what?
I forget. A few of them required movie watching, documentary watching. And I have not, you know what? I watched Dune twice in one weekend, and that is all the space
Nerd.
my brain had. Oh, I really needed to branch out.
I watched it.
Dune?
It's on HBO Max.
Did you go to IMAX first? Or did you?
I just watched it on HBO Max. It's
Okay.
very long.
See, Ray felt the same way, but Ray has read all 3 books. Well, there's 6 books, but he's read 3 of them. I'm not even halfway through the first book. I was just captivated by this movie. First in IMAX, and then on HBO. I was like, I got to watch this again.
Where we get our coffee, in your case, honeybush, raspberry, honeysuckle tea.
Apricot honeybush. Wait. Tell the listeners how you don't like to offer to get me anything anymore.
No, because it's awful when I go in there. I have to like whisper because it's like the most feminine tea drinks ever. But Abby, who works there, saw it in Dune in ID Formax.
What?
They like spray sand in your face. They drip water on you when you're in. I'm like, that sounds completely unpleasant. And like you, I think she went with her. She went with her boyfriend. I think she liked it, but I'm like, I'm too old for that. So
I
it's
didn't
like
even know
it's
that
like
was
a whole
thing.
other level. Don't tell Ray; he'll make you go and you'll get sand. put in
No,
your
he's
face.
just glad that I'm enjoying it. I just sat there eating a large popcorn in Junior Men's, which is bringing back childhood.
Mm-hmm.
Okay, so what are we talking about today, Pete?
Wait, I thought you were supposed to lead the discussion.
I will lead it, but
We're going to talk about the judge's decision in the Kyle Rittenhouse case. This is normally when I try to do the lead to the thing and you tell me that I'm not doing it right and hijack it. So let's see how long I get before you hijack it.
Okay.
Kyle Rittenhouse, this was the matter in Wisconsin where Rittenhouse had traveled from a neighboring state. He was carrying some sort of a rifle. I don't know if you're allowed to call it an assault rifle, but he had, a rifle with him. And there were protests in Wisconsin in August of 2020 related to a gentleman by the name of Jacob Blake being shot in the back by the police in Wisconsin. So this was like day 3 of the protest on August 25th. Rittenhouse shot 3 people. I think he killed 2 of them and wounded another. And now, oh, geez, I'm sorry. And now, in October of 2021, the case is going to trial, which isn't actually is pretty quick. It's about a year after the shooting. And what we were going to talk about is a judge's ruling on pretrial evidentiary issues. How did I do?
You did pretty well.
Thanks.
And the way those issues are raised before trial are in the form of motions by either party, and we call them motions in limine. And it's motions.
Can you spell limine?
L-I-M-I, limine, N-E.
Oh, my goodness. Good.
Okay. So in a motion in limine,
I wonder if that's Latin.
Sounds consistent with the rest of the
Latin
law.
or French. Yeah, it's probably Latin.
So whenever we're asking a court, or any lawyer is asking a court to hear an issue in a motion in limine, what that means is, Judge, can you admit this evidence or preclude this evidence, or can we frame this evidence a certain way?
Yeah. Admit it, not admit it, limit it, ask for clarification from a judge how you're going to be able to do it. Mm-hmm. I mean, in my practice, it's not very effective in terms of representing someone to just keep your fingers crossed and try to get it in and have the judge bite your head off in front of the jury. It's always better to lay it out and get a ruling ahead of time, because the worst thing you can do is get embarrassed, or get, not embarrassed, but get criticized before the jury by the judge for trying to get something in that you think you should get in, and they don't agree.
So meaning, rather than file the motion weeks or months in advance of the trial, waiting till the trial actually starts and then trying to admit the evidence, having the other side object to the evidence, and then arguing what is fair to the judge while a jury is just sitting there.
I think that's what I just said. That's not a good way to do it.
That's not a good way,
right.
But I'm trying to distinguish them practically for our listeners.
So we file many motions in limine.
Yes. Yes, we do. And in this case, a motion in limine, it seems was filed, it was at least filed by the defense. Was there a motion filed by the prosecution too?
I think they were mutual motions. The defense filed, by my count, at least 3-4 of them, and the prosecution had their motions as well. So this was a motion hearing before this judge, Judge Schroeder, in Wisconsin.
And you might have seen the headlines, listener. I mean, this was all over social media.
You said listener. That's my
listener singular. This was all over social media as prosecutors cannot call those shot by Kyle Rittenhouse victims, but looters, rioters. What was the third one? Looters, rioters, and arsonists is okay. And quite a few people sent, including you, Pete, sent me this tweet, these articles, and so we thought, let's just get in the studio and talk about it.
All right. Well, first of all, we're defense lawyers, so anytime a judge agrees that the prosecution should not be permitted to refer to their witness as the quote-unquote victim, that's a good thing, because that's something we argue, sometimes successfully, sometimes unsuccessfully. And from the defense perspective, it should be rather obvious, right? I mean, it's for the jury to decide if this person's a victim, not for, the prosecutor to keep beating them over the head, victim, 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 or the judge, worse, to use the term victim. You've heard the victim testify. Well, then why are we here? You know what I mean? So I think that's a good thing. Mm-hmm. You agree?
I agree. And part of my practice, and I think you may share at least some of this, I don't know if you're as OCD about it as I am, but in motions I file, anything I'm filing, any brief I'm writing, anytime I'm talking about the Commonwealth's main witness, I call the witness the complainant.
I used alleged victim. It's just easier.
I don't even like the V word.
I like alleged because there's like sarcasm dripping from alleged.
I also don't like the word defendant. And so in my motions, I'll say Miss or Mr. I will never call my own client defendant.
I agree with you. Oh, this is fun. Mm-hmm. I agree with you.
But
no, in front of a jury, I would never, you're always.
Even the court.
One thing I do remember from law school, I won't say where I went to law school because I didn't like it all that much. But
Villanova.
Don't stop. But that is one thing I do recall from law school. You don't refer to your client as the defendant or, something impersonal. You personalize your client. Now, that should be human nature. Most lawyers don't have, I don't know if it's human nature or personability, which is why a lot of them don't become litigators, or at least effective ones. But yes, long story short, I do agree. I always refer to the client either by their first name, if the judge will let me, or by the last name. But in pleadings, it's a judge. I don't care. I'll shorthand defendant and alleged victim.
No, it matters to me before a judge, too, because even if we don't go to trial, ultimately there might be a plea, there might be a sentencing, and I want that judge to feel like he or she knows my client.
Okay, so you're a better lawyer than I am.
Well, I just had better mentors, right? I guess.
Yeah, I guess. All right, so that's a good thing, that he wouldn't allow them to use the word victim.
And when you first saw this, I have a question. When you first saw this and you saw the first part of the headline, prosecutors cannot call those shot by Kyle Rittenhouse victims, were you like, oh, nice?
Yeah, I think that's a good thing.
And then,
but you know what? I'm going to get to my second part.
Okay.
Don't always believe what you read in a headline or in the press. Mm-hmm. Because while this is, it caught the attention of a lot of people, it's a little bit misleading to say prosecutors cannot call those shot by Kyle Rittenhouse victims, but looters is okay. That wasn't the ruling.
No.
If you look at I think it's the Esquire magazine article, there's a footnote where they do a correction.
At the very end.
Yeah. To be precise, the judge said that the terms rioters, arsonists, and looters could only be used in closing arguments, and then only if the defense has proven that any of the three people Rittenhouse shot, in fact, were rioting, looting, and or committing arson that night. So that's a little better. It seems pretty clear to me, by the way, that this judge is inclined toward the defense.
Yes and no. But we'll get to that.
All right, we'll get to that. But also, from this Esquire article, I had to look up a word. That's rare for me. Do you know what redolent means?
Where is it?
redolent. It's at the end, the thing I just read.
Less redolent form of bullshit.
Yeah.
Less at your fingertips.
I think redolent means more. I looked it up because I had to know how to pronounce it too. Like characteristic of. Here's the definition. I have it on my phone. Strongly reminiscent or suggestive of. But in any event, I thought that was a cool word that they used. Obviously, Esquire magazine is not thrilled with this judge because they said the judge, that this ruling is merely a slightly less redolent form of bullshit. Are we allowed to say bullshit on our
Well, we're just reading from an article, but I actually was thinking, to be precise, the judge said. So I'm thinking, did you pull this from the judge's ruling? And then I was confused by the last sentence because is that the judge's ruling or is that Esquire's characteristic of it?
Well, I mean, I trust Esquire. I mean, the article that I really liked was the NPR article. Okay, but here's the problem I see. It's inconsistent because if the judge is going to allow the defense lawyers to call them rioters, arsonists, and looters if the evidence shows that in their closing, Well,
Can
can't
the
the prosecutor say,
prosecution
well, I think I've proven that these guys are victims, so I should be able to refer to them as victims in closing?
I think that's a good point.
The better ruling would have been neither side can use those incendiary terms.
Well, here's the other.
It's another good word, by the way.
That's a good word. And I think that's a really good point. I didn't consider that. But what is the burden of proof? Because the defense usually doesn't have a burden of proof. So now what is the burden of proof to get to the stage of making the argument that they're arsonists, rioters, or looters? And what is the relevance of that?
Yeah.
Because I think the relevance, and that's an evidentiary basis for precluding or admitting evidence. I think the relevance in part of these arguments I read in one of the many articles was that the police were commending Rittenhouse.
You picked up on that. Darn it.
Go
I was
ahead.
going to ask you.
Please do.
This is a red herring. This whole rioters, arsonists, looters versus victims. Yeah, okay. So they can say certain words in closing or they can't say certain words in closing. The pretrial ruling, in my mind, that has the defense well ahead before the case even starts is this ruling that this video where police, on a video, showing police encountering Rittenhouse roughly 15 minutes before the shootings, tossing him a bottle of water and saying, "We appreciate you guys." So obviously the defense wants to get that in, right? You got the imprimatur of law enforcement before you go out and shoot these people.
But why, Pete? What's the
hold on.
basis?
The alleged basis. Listen, man, this is good defense lawyering.
Mm-hmm.
They said that it impacted his state of mind in terms of certain of the charges. They're saying first-degree reckless endangerment of safety, for instance, sounds like our recklessly endangering another person, requires prosecutors to demonstrate that Rittenhouse acted with, quote, utter disregard for human life, end quote. And what the judge said, if the police tell him it's a good thing you people are here, given the state of lawlessness that's existing, is that something that's influencing the defendant and emboldening him in his behavior, the judge said. That would seem to me to be an argument for relevance. So, the defense lawyers argued that the state of mind of Kyle Rittenhouse is relevant, and if the police are telling him it's okay to be there carrying his assault rifle, I don't know what else you're supposed to call it. I'm not trying to be political, but if he's carrying his assault rifle in Kenosha, Wisconsin, wherever heck he was, that he feels that he's not committing a crime. What a jury's going to see is they're going to see that these people are allowed to be called arsonists, looters, and what's the other one? Rioters. Oh my, sounds like that's all. And that this kid was getting encouragement from the cops. Juries like cops. That's going to be hugely significant when they see that. And it wouldn't surprise me if the defense attorneys perhaps argued the relevance of that video, even in a slightly more aggressive way, other than merely impacting Rittenhouse's state of mind.
I wonder if, as the prosecution, the argument would be, notwithstanding the police encouraging him to behave as he was and to commit those violent acts, the police themselves were acting with utter disregard for human lives. And so, taken together, I mean, it was just a mess.
Prosecutor's never going to concede that, but if I'm a prosecutor, it's not relevant whether a cop tossed him a bottle of water and said, "We appreciate you being here." What's relevant is whether he was justified in shooting these people. And I just think that when the jury sees that video, and knowing juries the way we do, that they like police, most people like police, they're going to say, well, the cop said he was all right there. Why are we here?
And then you have all these law enforcement officers taking the stand in the investigation and prosecution of this kid.
Yeah, and I have a feeling they're going to be rather tepid in their testimony. It'll be interesting. Reading these articles, I wonder if there is video out there that shows these three. What does the judge say they're allowed to be? Decedents. They're calling. He's using like different terms.
Looters, rioters, arsonists.
Well, he's not calling them that. He's instead of victims, they're decedents or complainants. Whether there is video showing that, because if there is video showing that, and then the defense has carte blanche to really kind of demonize them, then Rittenhouse does become like this, vigilante, like this law enforcement, deputized law enforcement guy in the eyes of a jury. I don't know, man. I agree with these articles that I don't think that it looks good from a prosecutorial perspective based upon this judge's rulings.
But these articles are a little, so we know from our practice and from news articles that what we put pen to paper to, or what we're litigating in court, is not usually reflected in totality in articles. I really wanted to see the actual motions in limine and the actual court ruling. And Donna said she couldn't find it. And I was bummed out about that.
The prosecutor, and this is a typical prosecutor argument, so why can't he call the victim an arsonist if that's what he thinks he can prove, Schroeder said. Prosecutors said that's a double standard. Their behavior that night has nothing to do with this case unless it was witnessed by the defendant, Binger said. Binger was the prosecutor. I have to think about that. I don't know that it necessarily needs to be witnessed by him in the context of what was going on there, whether you call it a protest. I mean, I think stuff was being burned, right? I mean, people were running through the city. So he's there. He's told by the police that we appreciate you being here. They see him walking around with a gun. And if these guys were shown to be participants in what was happening all around him, I wouldn't agree that he himself would need to witness what they did for them to be called that. The issue in the case is whether he acted in self-defense. I mean, he claims that they were running after him, that they tried to beat him with a skateboard. It seems to me, the issue is whether the shooting occurred first and then they ran after him, or whether they were running after him and then he shot. But no, I mean, on the one hand, I think that again, it's a good ruling. I always appreciate it when a judge sees the prejudicial nature of presupposing that someone is a victim. And then he had another one where he admitted a letter from a decedent, because we don't call them victims here, where she said, if I'm killed, look at my husband, and then she was killed. So he allowed the letter to come in, and he was reversed by the state Supreme Court. But then he made a point of, and this was in the context of this case, saying, kind of defending his evidentiary rulings. He said I was overturned by the state court, but then the federal court said I was right. So there's that. He sounds like a real character, and you have to. It sounds to me like the defense lawyers there know the hand that they have, and they're playing it to their advantage.
As they should. You protect your client. Okay, well, that is what we wanted to talk about. Do you want to share with the listeners about our practice growth?
Why don't you do that?
Okay. So we have a new lawyer who's practicing with us. Her name is Mary Lawrence. She just passed the bar. She's an associate attorney now, and we're thrilled to have her. One day when we can figure out how to get a third microphone linked up in this room, we'll include Mary, and she can just really explain all the glory that is working with you and me.
And by that, you mean you.
Yeah.
Yeah. Yeah. Mary is a person of few words. She's obviously highly intelligent, because the more you talk, the less intelligent you are, which, guilty.
I mean, we're screwed.
So I think it would be fun to get her in here and make her talk.
She hates it.
I know.
I love putting a client in front of her and be like, can you do the colloquy? And she's like, no. But we're excited to have her. And as I was sharing with Pete the other day, Mary just had her passing the bar party. We're going to take her to get a drink today. But it made both of us remember, years ago when I was a new associate at McElroy Harvey. I wasn't yet with Pete. I was a business attorney, and we just walked down that memory road, and what nice memories.
Yeah, what nice memories. Business lawyer, right.
All right, Pete, anything else you want to share with the listeners?
No, very good.
You want to tell Lauren it was her call you screened?
Oh, I already told her. I said, stop bothering me. They want me to DoorDash them food. I won't do it.
Your kids.
Yeah.
You're a good dad if you're going to DoorDash them food.
They're spoiled rotten.
Well.
All right. They wouldn't be caught dead listening to this.
Oh, well, then we can say whatever we want.
That's right.
All right, listeners, thanks for tuning in to Subject to Cross. We will be back with more topics. Please send us emails. We appreciate your emails. It does give us...
One of us reads them.
You should read them.
I don't get them. I swear to God, I don't get them.
I will send them to Pete with high importance.
You need to have that red exclamation mark thing.
That's high importance.
Okay.
All right. Email us subjecttocross@mcelry.com. Signing off.
Bye.